case briefs, and so much more. LSData's got what you're looking for.
The 2006 case Engelke v. Estate of Engelke, heard by the Florida District Court of Appeal, focused on the heir's entitlement to homestead protections under Florida law, despite a property being held in a trust. This prevented creditors from forcing the sale of the property to pay estate expenses. The dispute involved the personal representative of an estate and the successor trustee of a revocable trust. The court was asked to decide whether the trustee was required to pay the claims and expenses of the estate. The primary asset of the trust was a 1/2 interest in a residence, which the trustee claimed was protected by Florida's constitutional homestead protections. The court found that homestead protections attached to the residence because the decedent retained all control over his homestead during his lifetime and did not convey any vested property interest in the homestead to the trust. In this case, Paul Engelke, the decedent, had entered into an ante-nuptial agreement with his spouse, Judy, in which they both waived their homestead rights. Upon Paul's death, Judy continued to reside in the home and will pass on her 1/2 interest to the beneficiaries of her trust upon her death. The court ruled that the trustee was not required to pay claims and expenses of the estate, preventing the sale or encumbrance of the homestead property. The heir's interests in the residence were protected by Florida's homestead protections, despite the property being held in a revocable trust. The court also affirmed other issues in the case.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class.